what I hope will be so just to let you know, you'll have heard a message that the webinar is being recorded. So welcome everyone to what I hope will be an interesting and important event to discuss the upcoming 6-month review of the Coronavirus Act 2020, which is due to take place on Tuesday, 19th of October. It's a pleasure to have you all here. So, as we know, the Coronavirus Act is the government's flagship pandemic legislation, which gave the government extensive powers to manage the pandemic last year after it was fast-tracked through Parliament in a matter of days before Parliament went into the Easter recess last year. The 6-month reviews required by Section 98 of the Act were included during legislative scrutiny as an additional safeguard and provides MPs with the opportunity to debate and vote on a motion which states that the temporary provisions of the Coronavirus Act 2020 should not expire. In the case that the House of Commons rejects the motion, the government must then expire the provisions within a period of 21 days. So we're here to discuss this review process from the perspective of effective parliamentary scrutiny and government accountability. I'm very pleased to be able to introduce our 2 speakers to discuss this topic. Speaking first, I'm very happy to introduce Katie Lines, who is a research fellow in rule of law monitoring of coronavirus legislation at the Bingham Centre for the Rule of Law. Katie's work at the Bingham Centre is part of the Rule of Law Monitoring of Legislation project led by Dr. Ronan McCorkane. The project aims to systematically scrutinise government bills from the perspective of the rule of law and to report on bills which have significant rule of law implications. Following Katie, we will hear from Fiona de Londres, who is a professor of global legal studies at Birmingham Law School and principal investigator at the COVID-19 Review Observatory, or CIVRO. CIVRO is a resource which is funded by the Arts and Humanities Research Council that records, tracks, and assesses reviews of responses to the COVID-19 pandemic from a human rights perspective. Much of its research from the last year has focused on Parliament's role with respect to the Coronavirus Act in the last year and a half. So the 2 speakers will begin this webinar by speaking for 15 minutes each, and then we will move on to questions. If you have a question you'd like to ask, please send them through to me on the Q&A box. I'll pass over to Katie first.
Great, thanks, Daniela. So in the next 15 minutes, I'm going to discuss the effectiveness of the review provisions in the Coronavirus Act and ask how well they've fulfilled their intended function, which is, as Daniela mentioned, to provide post-legislative parliamentary scrutiny of the Act to compensate for the very limited scrutiny that Parliament was able to undertake during the initial stages of the bill. So I'll start by giving an overview of what the review processes are. As Daniela mentioned, the principal review process built into the Act is the 6-month parliamentary review provision, and that provides that every 6 months a minister must, as far as practicable, make arrangements for the House of Commons to vote to keep the temporary non-devolved provisions of the Act in force. And the temporary provisions of the Act include almost all the most significant measures introduced by the bill. The only significant power that's permanent is the power given to the HMRC and the Treasury, which allowed them to create the furlough scheme. If the House of Commons votes in the 6-month review not to renew the temporary provisions in the Act, then the government has to make regulations which terminate their use within 21 days. So that effectively brings the operation of most of the Coronavirus Act to an end. And then there are 2 supplementary processes which are intended to help the House of Commons decide whether or not to renew the temporary provisions during those 6-month renewal debates. The first of these are 2 monthly reports, which the House Secretary is required to produce, discussing the operation of the non-devolved provisions within the Act. And the second of these is a 1-year status report that the House Secretary was required to produce at the halfway point of the Act, because there's a 2-year sunset clause. So that was produced in March 2021, and both Houses of Parliament were required to debate that. So the purposes that these review processes are meant to fulfill is to provide post-legislative scrutiny and accountability for the operation of the Coronavirus Act, to substitute the very limited pre-legislative scrutiny that Parliament was able to undertake when the bill was passed. as we'll all be aware, the coronavirus bill was rushed through Parliament in rapid speed to deal with the emerging crisis at the start of 2020. And the 6-month review debate provision was something that was added to the bill as a cross-party amendment when it was being debated in the Commons. And at the time, Andrew Mitchell, a Conservative Member of Parliament, expressed the hope that the 6-month review would function not just as a rubber stamping effort, but as a chance to improve the legislation should it require improvement. So how well has the 6-month review process acted as a chance to improve the Coronavirus Act and provide Parliament with an opportunity for post-legislative scrutiny? I think the general consensus and my view is that the 6-month review process hasn't fulfilled that function as well as it could have done. And I'm going to highlight now 3 main problems with the 6-month review process. One, which is an inherent problem encapsulated in the way that the review process has been drafted. And the other 2 are practical problems which have arisen as the review process has been used and aren't an inherent defect with the drafting of the 6-month review process in itself. So to move on to the first of these, which is the inherent problem, as I see it, in the drafting of the 6-month review process. The 6-month review motion gives the Commons an all or nothing vote. They can only vote to renew or expire all of the temporary provisions in the Act. They cannot vote to suspend or expire individual provisions that, for example, might not be needed anymore or might just not be working as intended. The Commons has to take an all or nothing approach. If the Commons votes not to renew the Act, then the government, as I mentioned earlier, must expire the temporary provisions of the Act within 21 days of the vote. So this only gives the government 21 days to create and pass through Parliament new legislation to replace most of the provisions in the Coronavirus Act, which would have then been expired by that point. So voting to expire the temporary provisions would have enormous political and practical consequences that mean that in practice, this option just isn't really on the table for the House of Commons. The Commons only really has one option, which is to vote to renew the temporary provisions in the Act. So this means that the 6-month review process is drafted in a way that effectively guarantees the outcome will be a vote to renew the temporary provisions in the Act. And this point was raised in both Houses of Parliament when the coronavirus bill was being debated. So it's regrettable that concerns raised at that stage weren't acted upon and the review process wasn't amended to allow the Commons the option to amend, sunset or amend, suspend or expire individual provisions within the Act. I'm just going to quote David Davis, a Conservative MP, who in the Commons second reading raised the concern that faced with 8 good bits of legislation and 1 or 2 bits that are doing badly, we will be forced to vote the whole thing through, rendering the vote a rubber stamp. David Davis's concerns have largely been borne out in the renewal debates themselves. When members of Parliament have floated the option of not renewing the Act, the House Secretary has responded with fatalistic statements about what the outcome of such a vote would be. I'm going to give one example of these, which was made in the 6-month renewal debate, when the House Secretary said, the principle of the Coronavirus Act is that it underpins so many of the actions that are necessary. To vote down the Act and not to renew it would lead to an undermining of the actions that we need to take to keep this country safe. Here, the vote not to renew the temporary provisions is presented as a nuclear option, which I think most members of Parliament would be very reluctant to take. So I think it's right to conclude that making the 6-month review process an all or nothing vote has backed the House of Commons into a corner where their only real option is to vote to renew. And as well as this inherent problem that's baked into the drafting of the 6-month review process, there are 2 more practical problems that have arisen, not from the inherent design of the review process, but due to the way that it's been used in practice. And the first of these problems arises from the scheduling of the renewal debates. So far, insufficient time has been allocated for the renewal debates, which has prevented proper scrutiny by the House of Commons of the temporary provisions. The first 6-month debate was scheduled only for 90 minutes and backbenchers were given a 3-minute time limit to their speeches. At the time, the House Secretary, Matt Hancock, said that the standing orders of the House only allowed the debate to be scheduled for 20 minutes. But during the debate, the Speaker of the House contradicted this and said that the time for debate could have been extended, and he would have agreed to it being extended had the House Secretary asked. I think that 90 minutes just isn't enough time to debate a 359-page act and the operation of that act in 6 months of a pandemic. And members of Parliament raised similar sentiments during the debate, sometimes using strong language. For example, Sir Charles Walker, who's a Conservative member of Parliament, said that 90 minutes is an utter disgrace. It is actually disrespectful to this House, and it is disrespectful to colleagues. On the surface, it looks like these concerns raised in the Commons were taken into account when the one-year debate was scheduled earlier this year in March. Significantly more time was allocated for the debate, 3.5 hours in total. However, the renewal of the temporary provisions within the Coronavirus Act was not the only motion debated at this time. The House of Commons was also asked to consider 3 of the motions at the same time. The first of these being the consideration of the one-year status report, the second being a motion to approve regulations implementing the roadmap out of lockdown. And these were obviously very significant regulations, which the Commons wished to consider in detail, given that they marked the end so far to the lockdown rules that had been in place since January. And then thirdly, there was a procedural motion debated, which extended some temporary standing orders. I think it makes sense for the one-year status report to be considered at the same time as the renewal debate, but it's not clear why these latter 2 motions were scheduled for debate at the same time as the 6-month review debate. If all these motions had been debated separately, then they would have been subject to more cumulative debating time than they received by rolling them all into one debate. So scheduling all 4 debates at the same time limited the amount of time that the House of Commons had to debate the 6-month review. And this time around, backbenchers were given a 4-minute time limit to their speeches, which is only a 1-minute improvement on the time limit imposed during the 6-month renewal debate. And again, members of Parliament expressed dissatisfaction with the amount of time that they were given, with Karen Bradley, a Conservative member of Parliament, stating that 3.5 hours for a debate on these topics is simply not enough. And I agree with that sentiment. I think more time needed to be scheduled to enable full parliamentary scrutiny of the renewal of the temporary provisions. And then the second practical problem that I see with the operation of the 6-month review process is the level of information that members of Parliament have been given in the 2 monthly and 1-year reports, which the Health Secretary has been required to prepare. These reports are meant to provide Parliament with the information that they need to assess both how the provisions of the Act are working in practice and whether it is necessary and proportionate for these provisions to continue to be in effect. And at the moment, I just don't think enough information is provided to allow Parliament to undertake this assessment. The reports are largely narrative discussions which set out which sections of the Act are currently in force and which the government intends to expire. They do discuss what impact each provision, or most of the provisions of the Act that are operational, has had, but these summary of impacts are very brief, and I think crucially they don't draw upon the huge amount of work that parliamentary committees have undertaken scrutinising the working of the Act, and I think that's a real missed opportunity. To give one example from the most recent 2-monthly report, which members of Parliament will be considering next week when they consider the 18-month renewal debate. The report considers sections 53 to 56 of the Coronavirus Act. These sections expand the use of remote technology and live links in criminal proceedings. And from reading the report, you would think that the expansion of remote proceedings has only had positive impacts. The report explains that these provisions allow the courts to deal promptly and safely with proceedings, avoiding unnecessary social contact and travel, whilst allowing key services within the justice system to be continued to be delivered while upholding the principle of open justice. But both the Joint Committee on Human Rights and the House of Lords Select Committee on the Constitution have independently considered the impact of the shift to remote hearings and have raised concerns that remote hearings and the introduction of live links, expanded use of live links, is negatively impacting access to justice. The House of Lords Select Committee on the Constitution concluded in its report that the shift to remote hearings may have undermined litigants' ability to engage appropriately with courts and tribunals potentially to the detriment of their own case, and created difficulties for effective communication between court users and their legal advisors, which could be undermining access to justice. This is the type of information that Parliament needs to have before it in order properly to decide whether the temporary provisions of the Act should remain in force. And it's disappointing that the 2-month reports don't make more use of the wealth of information and the many hours that parliamentary committees have put into scrutinising the working of the Act so far and producing reports to assist the government and the House of Commons with its consideration of the Act. And just to end this section, it's not only me that thinks that the 2-month reports are inadequate. In September 2020, the Public Administration and Constitutional Affairs Committee found that the reports did not give enough detail to be an effective tool for scrutiny. So just to conclude, the review processes within the Act have largely been inadequate at compensating for Parliament's reduced opportunity for scrutiny when the bill was being debated during its initial passage through Parliament. And I think it could even be argued that the 6-month review process does more harm than good. By giving the Commons an all or nothing vote on the renewal of the temporary provisions in the Coronavirus Act, Parliament is effectively forced to vote to renew the Act, even if some of its provisions are deeply unsatisfactory or harmful. And this gives the illusion of scrutiny while not providing proper scrutiny in practice. Maybe if the 6-month renewal mechanism had not been inserted in the Act in the form that it has been, then more extensive scrutiny measures could have been provided for that would have guaranteed proper parliamentary scrutiny.
Great, thank you so much, Katie. I'll now pass on to Fiona.
Thank you, Daniela, and thank you everyone for joining us this lunchtime. I thought it might be useful, building on Katie's intervention, with which I am entirely in agreement, to reflect on some of the broader implications of how the 6-month reviews have been operating and have been operationalized by government over the lifetime of the Coronavirus Act. I do this conscious that the Coronavirus Act and the 6-month reviews thereof are only one part of a broad legislative patchwork that frames the pandemic response, and which of course includes a large amount of delegated legislation introduced under the Public Health Act, as well as regulations under the Coronavirus Act, secondary legislation in the devolved parliaments, and in Scotland, primary legislation governing the Scottish Government's response. So I suppose the first thing that we should mention, and it is no surprise to anybody who's with us today, is that the 6-month reviews may arguably become a little bit lost in the mix of parliamentary, executive and administrative actions that are implicated in the pandemic, as at times might the Coronavirus Act itself, because it's such a complex and dense landscape. So I think this begins to gesture towards one of the broader implications that we might draw out here today, and that is that MPs perhaps are simply not always completely clear about the legislative source of powers or interventions that they are concerned with, so that one might wonder whether some things are being missed in 6-month reviews or some non-relevant issues are being brought into the 6-month review debates because the legislative framework itself is so dense and complex. Others, of course, have done extensive work on the delegated legislation here, not least the Hansard Society and its tracker. But there's also, I think, a piece of work to be done on the manner and extent to which MPs are effectively informed about the content, nature, scope, and status of powers under the Coronavirus Act that are actually in force at the time of a debate. And this, I think, builds on the point that Katie was making about the 2-month reviews. Now, I should note, to be fair to those reports, 2-month reports, that they do attempt in some ways to provide information about the status of the powers, which is in essence what they're supposed to do. They include what they term a status table that goes through all the different provisions, as well as 2 tables that purport to track the changes in status of powers, first in the reporting period, that is in the preceding 2 months, and secondly, since the enactment of the Coronavirus Act itself. However, echoing what Katie was saying, these tables are not very precise or very well detailed. They don't always give the name of the specific statutory instrument or other regulation that they say is due to be expired. They provide links, but they do not always take you to the correct or the final version of the relevant instrument. Of more substantive concern, perhaps, is that in these reports, we use some unclear terms. So some powers are listed as being due to expire without information about when the expiration will actually take place. And in some cases, it looks like it's taken up to 2 months from the time of being due to expire to expiry. Furthermore, they sometimes are either erroneous or incomplete, depending on how one reads them. So for example, the 1-year review stated that extended powers to store DNA data and fingerprints were to be expired, but in fact, only one of the 2 relevant regulations were to be expired. This was then clarified in a correction paper published during the recess. Thirdly, sometimes powers are listed as suspended rather than expired or enforced, with no real indication given as to how long they're to be suspended for and in what circumstances they may be brought back into force. So all of this goes to that point that MPs are being asked in the 6-month review to undertake a legislative framework that is in itself complex and sometimes technical, but with patchy and sometimes unclear information and a level of detail that is either insufficient or impenetrable, depending on what particular power you're looking for. I think this, of course, is particular to the 6-month review in respect of those reports, but also points to a broader challenge we're already familiar with of parliamentary scrutiny in an area of regulatory density, where regulation is taking place across primary, secondary, and indeed tertiary scales through, for example, Treasury directives, as is the case here. Now, it's worth noting that this could be done better. This is not inevitable. In Scotland, for example, there is both a 2-monthly report on their coronavirus legislation and a requirement to provide a statement of reasons justifying the extension of powers. The statement has generally been laid by the government 1 month in advance of a debate on extension. It is laid with the report, there's a ministerial statement on it, and then there's a debate in the chamber. The 2 monthly reports are also in Scotland scrutinised by committees, or the first 5 were by the COVID-19 committee, which points towards the usefulness of having a dedicated committee to contribute in this sustained way to scrutiny. The statement of reasons, which accompanies the 2 monthly report, and in Scotland, those reports are extremely long and detailed, is an opportunity to provide a more accessible summary to the members of Parliament there, to highlight key points and to provide context and justification relevant to and directly engaging with the decision that Parliament is being asked to endorse. In my view, this leads to a significantly more informed debate than we have seen in the 6-month review debates in the Commons, and also shows how the provision of usable information to enhance scrutiny can be undertaken by government. Now, challenges of regulatory density are not the only dynamic in play here when we think about the 6-month review. And I think in particular of that inherent problem that Katie mentioned in the design of the 6-month review, as well as the timing issue. Because I think the dynamics of regulatory density that I've just mentioned and of information provision are exacerbated by a pattern of parliamentary marginalisation that has been observed over the course of the pandemic and which has been manifested in a number of ways. Indeed, one might argue that the decision to introduce the Coronavirus Act itself, to do so with great urgency, to limit pre-legislative and legislative scrutiny, and to schedule the debates, as Daniela already mentioned, in the days immediately preceding a recess, is perhaps paradoxically an indication of the marginalisation of Parliament. This argument would proceed on the basis that there was already, and it may have been more appropriate to use, a legislative framework that comprises the Civil Contingencies Act and the Public Health Act, in combination perhaps with a piece of gap-filling legislation that may have tied them together in ways that were particularly required for the pandemic. So by electing for an under-scrutinised act passed by an executive-dominated legislature acting in a situation of emergency over a pre-existing, well-understood and established legislative framework passed by a previous parliament outside of emergency circumstances, the government was in principle indicating perhaps or acting in a way that had the effect of marginalising Parliament in a strange but nevertheless interesting way. On top of that, as already mentioned, we have the heavy reliance on delegated legislation, in particular on regulations which are sometimes expired before they ever reach scrutiny in Parliament. When considering regulations, just as when considering the 6-month reviews, MPs have remarked expressly that they feel like they are simply rubber stamping a set of decisions, that they do not have capacity to influence or meaningfully to scrutinise those decisions in Parliament. Other techniques of marginalisation may initially be read as mere matters of prime ministerial style, but actually communicate a disposition towards Parliament and towards being answerable to Parliament that may suggest a larger difficulty. I'm thinking here in particular of the practice of making policy announcements and sometimes even legislative announcements by press briefing or conference speech rather than to the House of Commons itself, a practice that has been widely criticised. One effect of this is that to some extent MPs are then limited to trying to challenge or get clarity on these proposals in forums such as Prime Minister's questions, which are fundamentally ill-suited to substantive debate and discussion because of both their format and the cultural practices of promotion, bravado and theatre in which they are bound up. So there are very limited opportunities for Parliament to be meaningfully involved. In my view, we see some of this reflected in the debates on the 6-month renewal motions themselves. In some cases, these debates have been dominated by broad frustration about Parliament's marginalisation during the pandemic, or even internal party tensions with, for example, the Brady Amendment dominating a lot of discussion around the time of the first 6-month review, as well as concerns that are not germane to the temporary powers then in force under the Coronavirus Act, but which perhaps MPs air in this setting because the 6-month review debate is the time during which the statute mandates that the government must subject itself to this form of scrutiny. Of course, this has the effect of diluting the focus of the review, which one might argue reflects MPs' lack of engagement with the detail, and to some extent it does, but which also, I think, can be read as partly produced by a broader problematic executive posture towards Parliament. When we combine this with the external problems Katie has already mentioned of inadequate reporting, limited time for debate, and the packing of debating time with other motions, it's clear that the 6-month review is always going to struggle to function as an effective forum for accountability of government before Parliament. Now, I think all of this should concern us for a number of reasons. It seems to really bring into focus the sharp edge of executive dominance in Parliament. Of course, executive domination is not new, but at the moment we have 3 factors that combine to make its effects especially clear. These are, of course, a huge majority for the government, an emergency or crisis situation, and an apparent executive ill-disposition towards the constitutional principle of accountability to Parliament and towards recognising Parliament as the superior organ of the state. This is beginning to lay bare, I think, the extent to which the UK's constitution, like all constitutions, relies on a commitment to constitutionalism among its organs and institutions in order for it to function well. So the executive is meaningfully answerable to Parliament, not only because that is the constitutional structure, but also because an executive does not abuse its dominance and subjects itself to the principle of answerability, or to draw on Mark Bobbins' work on accountability, embodies and enacts the notion of accountability as a virtue. I think there's a chance that we are seeing through this pandemic a glimpse of what might happen if the executive does not commit to and enact the virtue of accountability and does not have a strong commitment to constitutionalism and to its role, along with Parliament and the courts, as a constitutional labourer that must maintain constitutional principle through self-discipline, comity, and constitutional orientation. I think in some ways that's why the forthcoming review next week matters so much. It's not only because some of the powers that are currently temporary under the Coronavirus Act are likely to become permanent in the coming months, most likely, I think, through secretion in other pieces of legislation, as we're seeing at the moment with powers related to video-linked court proceedings, rather than a single piece of new primary legislation. I note that in Scotland, the government has already announced that it plans to make some of its temporary powers permanent. It's also important that is next week's 6-month review, because the way that these reviews have functioned may be read as a microcosm of constitutional fraying that has been revealed and exacerbated by the circumstances of the pandemic, and which I think broadly one would certainly like to see arrested, or at the very least resisted, by MPs in the opportunity they receive next week. Thank you.
Thank you very much, Fiona. Thank you both for your very interesting and thought-provoking discussions. We will now move on to some questions. The first one I have here is, as well as the nature of the motion that the Act provides for in respect of these reviews, are there other organisational or procedural matters that you would say shape or influence the conduct and rigour of the review debates? Would you both speak for around 3 minutes on this? Casey, it'd be great to hear from you first.
Thanks. Yeah, I think the rigour of the review debates has been negatively impacted by two of the problems that I raised earlier. So the time afforded to parliamentarians to debate the renewal motion and the lack of information that's provided. I was surprised, Fiona recently published, and you, Daniela, both of you together recently published an article looking at the one-year renewal debate. And you raised that really limited reference to work of committees or any substantive engagement with some key provisions within the Act that have had really negative implications. And I was also surprised to see how few references there are in the renewal debate to the huge amount of work that parliamentary committees have conducted in carrying out scrutiny of the Act. And I think a lack of scrutiny doesn't just affect the provisions in force for the next 6 months, or if they're extended, because some of these provisions may become permanent beyond the end of the coronavirus pandemic. I'm thinking in particular of the expanded use of live links and digital proceedings in criminal court hearings, which I mentioned earlier. The government's now intending to make those permanent through the Police Crime Sentencing and Courts Bill. And if the House of Commons hasn't had an opportunity properly to consider the impact that live links have already had during the pandemic, it's harder to identify any longer term adverse impacts that might result once those provisions, if they are made permanent, are done so.
Yeah, thanks. I agree with Katie, and I just pick up on two other sort of procedural or organisational matters that I think are contributing to the limitation here. The first is just, and this maybe sounds a little trite, but it's just the format of the debate. You know, the Secretary of State stands up, or the government stands up and introduces the motion, perhaps with a few interventions that they have discretion, of course, to take or not. And then there is usually one large bulk of comments and reactions with very limited time, as Katie's already mentioned, from members. And then at the end, a government response. And what you see very clearly is that the government cherry picks what points that have been raised or concerns that have been raised, it engages with. Now, that of course is not particular to this kind of debate. It is part and parcel of parliamentary proceeding, but it does mean that things often just aren't picked up or followed up on or responded to in any kind of meaningful way in the debate itself, so that there isn't a more robust exchange So the question then becomes, how you might address that. And this points to the second organisational matter that it might be worth mentioning. And that is that there was never established a dedicated committee in Westminster to deal with COVID or COVID related matters. And of course, that wasn't the case everywhere. Scotland had a COVID-19 committee, which is now something like the COVID-19 Recovery Committee or something. In the new Parliament, it has a different title. But that committee was able, at least on some occasions, to do the heavy lifting around scrutinising the government's reports and placing, having a good exchange, robust exchange with government around the effects, the implementation, the extent of use of various powers under the Scottish legislation and the devolved powers here. And I think it really, although I don't want to suggest that Scotland is a model of perfection, but it is something very interesting that COVID-19 committee, was an important actor both in review processes and in the scrutiny of the proposed primary legislation in Scotland. And the lack of any such singular body in Westminster was something, that limited, I think, the Parliament's ability to try to maximise the opportunity for scrutiny that even this limited statutory provision allowed for.
Great, thanks both. I've got a second question here. So it's asked that periodic review of this kind is being proposed around a range of different pandemic-related powers or legislative developments in and around in and beyond Westminster. For example, mandatory vaccination for NHS workers, Scottish Coronavirus Acts, etc. So is there one key takeaway lesson you would say can be taken from the experience of periodic review under the Coronavirus Act, which would make such reviews more effective? Katie and then Fiona.
Yeah, I think my takeaway goes back to the drafting of the legislation that would implement reviews and the need for that to be really carefully considered and tightly drafted. So probably in two ways. I mean, we've seen that an all or nothing renewal motion doesn't really work. So there needs to be consideration as to what powers Parliament is given during the renewal debate, and preferably, I think they need to be given an opportunity to vote to amend, sunset, or suspend individual provisions. And then more broadly, that legislation implementing periodic reviews needs to very clearly set out what the government needs to do in order to ensure that those reviews operate effectively, and that discretion shouldn't be left to the executive to determine primarily the amount of information that Parliament's given when considering the renewal debate. So I'm thinking reports, I think, can be useful, but they need to be, I think primary legislation should really clearly set out exactly what those reports need to contain. So whether they need to cite scientific evidence, give indications of levels of compliance with measures, include any relevant findings from committees, contain a proper proportionality assessment. I think there needs to be much more specific delineation of any powers that are given to the government to facilitate those periodic reviews.
Yeah, I would just build on that, particularly the second point, to say that something like the statement of reasons, is that you have in Scotland is something that could be looked at in an attempt to do that, to fulfill this function that Katie is talking about. I think that being highly prescriptive about the content of reports, can sometimes backfire, because you may end up with a very performative set of text, or the repetition or copy and pasting of text from one report to the other, which we all already see in reports of this kind. So there is a delicate and difficult balance to be struck between, communicating what the function of the reports is, and not having the reports become a sort of tick box exercise. And I think that's one of the things that has happened with the Coronavirus Act, is that the status of powers report is not effectively linked, I think, in the legislation or in the parliamentary mind with the review process. So as well as sort of not being sufficiently clear about what the reports should contain and the kind of information they should contain, there also isn't a clear link into what their function is, not an express link into what their function is within the context of the review process. So requiring a statement of reasons for extending or continuing with powers might create that sort of link between the report and the renewal. Now, it is worth saying, I suppose, that these statement of reasons even and reports are not necessarily engaged with very in great depth in the Scottish Parliament, and there will always be the challenges of parliamentary time and parliamentary attention. But the function of these reports should be to draw a map for members of Parliament between the powers, their effects, and the proposal to maintain them, or indeed to expire them, so that they are explanatory and that they assist scrutiny rather than being simply the provision of information in order to fulfill a statutory requirement. Sorry, Daniela, I don't think we're hearing you. No, it's okay. I can see the questions.
Okay.
I'll go. Oh, you're back. You're back.
Yeah. Can you hear me okay?
Yeah.
Great. So the second question is, given that the Coronavirus Act is only one of the many pieces of primary legislation allowing the making of COVID rules, is it actually a nuclear option for Parliament to accept or reject it in its entirety? For example, even if the Act was not renewed, the regulations made under the Public Health Act would still remain in force, and these are all the lockdown rules and international travel rules. Who wants to go first?
I described it as a nuclear option, so I should probably back up that statement. So I of course, many of the coronavirus rules don't come from the Coronavirus Act. As you mentioned, Ronan, the lockdown regulations, international travel restrictions, hotel quarantine all came from regulations made under a different Act, Public Health Act. But that doesn't mean that the Coronavirus Act doesn't implement wide-ranging measures, some of which have now been sunsetted, but especially at the 6-month review debate, implemented wide-ranging measures that, if these were rejected by Parliament, it would have been a significant statement, and the government would have had to scramble to put new measures into place. So I'm thinking of protections from evictions for renters, statutory sick pay for people who are required to self-isolate. Local authorities were able to relax their social care duties at the very start of the Act. I think if these provisions were suddenly due to expire in 21 days, that would create a lot of uncertainty and, like I said, a scramble to put new measures into place. And then also, I don't think you should underestimate the symbolic importance of the House of Commons voting to expire the Coronavirus Act. And I think in the minds of the public, like Fiona said, it's not always clear where rules come from and what legislation does what. And I think the Coronavirus Act is a much more recognisable piece of legislation than some of these other regulations which might make similar provisions. But I think a headline that the House of Commons has voted to expire the Coronavirus Act would have significant political implications as well as the practical implications that I've already mentioned.
Yeah, I agree. I agree with that, and I think also it's worth noting that the idea of non-expiry as a nuclear option was very much pushed, by the Health Secretary in the debate. So it was exactly the things that Katie was just mentioning: statutory sick pay, protection for tenants from eviction, that he surfaced as the things that would be lost if the House did not vote to renew. And of course, there are what was never, I think, properly acknowledged was that the vote not to renew would not result in the immediate loss of all of these provisions. There was this 21-day period in which something could be put in place to replace them. and to ensure that those protections and provisions were still available to people. So it was not just, I mean, I get the point that there are lots of powers that would remain in place, but it is that this was communicated to the House of Commons as this sort of hugely significant thing to do that would undermine and frustrate the country's attempt to counter this disease and to manage the pandemic, which of course is resonant of the sorts of rhetoric that you hear in emergency situations, generally a kind of rally around the flag rhetoric, which makes it extremely difficult to oppose in a meaningful way. And even when alternatives were in fact placed before the government, like in the one-year review, Labour members tabled an alternative act, it never received any serious consideration. Of course, because the government knew there was no real likelihood of it, of the renewal motion not being successful.
Can you hear me okay? Great. I just want to pick up on a comment that was made in our chat section, which was just to highlight that the House of Lords has a COVID-19 committee, which was set up to examine the kind of more long-term issues related to the COVID-19. And this is linked to the idea that the select committees would only be able to focus on the short term. I'm not sure how much we've had from that committee yet, and I've never seen the committees, the work of that committee being reported or recorded in the 6-month reviews. Maybe the next review we'll see something different. So I've just got one more question, and then I think we'll wrap up. So this is another one. This other one says, does the all or nothing approach to votes on the renewal of the Act make the review process a waste of time, or is there anything of value in the review debates or motions? Katie, would you like to go first, or Fiona?
Yeah, I'm happy to go first. No, I don't think it is a waste of time, although, as I mentioned earlier, I had concerns that maybe having this all or nothing vote gives the illusion of some scrutiny happening, and if the 6-month review provision wasn't in place, the alternative provisions could have been made to provide for proper scrutiny. So, for example, only having the Coronavirus Act in place for a short amount of time in the immediate stages of the pandemic, and then bringing a parallel act through Parliament that was able to be properly considered, maybe contained many of the same provisions, but had proper scrutiny. I think the renewal debates have given parliamentarians an opportunity to raise issues within the Coronavirus Act, but also broader issues at a time when they know that the public is going to be watching, and the House Secretary has to give an answer. So I'm thinking in particular of the 6-month renewal debate, where an amendment was tabled relating to the lockdown regulations, which were made under a separate act, but trying to force the government's hand to allow Parliament to vote on regulations implementing lockdown or other significant measures before they came into force, so the Brady Amendment. And the Health Secretary made a promise to Parliament that would happen whenever practical, so that the 6-month renewal debate provided a forum for those types of conversations to happen.
Yeah, I think that's right, and I think broadly there is an important value to there being a period of time that has to be dedicated to the discussion of this act, and thus, as Katie was mentioning, creating an opportunity for other scrutiny concerns to be raised, even if they're not expressly related to the Coronavirus Act. So I would say that it has a value that may not be precisely applicable or limited to the Coronavirus Act, but there is nevertheless a value that this provision and the debate that it gives rise to brings to Parliament's capacity to scrutinise and to try to achieve and ensure accountability for the management of the pandemic by securing an opportunity. But one thing to mention, and just going back to Bridget Fowler's comment, which of course is right, on the House of Lords Committee, and there is an APPG as well on COVID-19. But it is of course interesting that the 6-month review or renewal motion is to be debated by the House of Commons, but not by the House of Lords, according to Section 98 of the Coronavirus Act. So, and this was picked up on at the time that the Act was being debated initially, of course, in the Lords, with a number of peers expressing real concern at their exclusion from this process, but they are nevertheless excluded from the 6-month process, which, you know, may be one reason why the House of Lords Committee materials do not seem to be landing within the 6-month review debates, but broadly speaking, as we've already mentioned, committee reports are not really prominent. It will be interesting to see next week whether the joint report of the Health Committee and the Science and Technology Committee, which was released this week, will feature. I suspect it will feature strongly in next week's report, but of course it's received an awful lot of attention and it's temporarily proximate to the debate, which also helps with trying to ensure it's on the agenda.
Great, many thanks both. So I see that the time for the webinar to come to a close has sadly come. I think that the discussion here today has demonstrated that there's much more to unpick with regards to the significance of the upcoming review and the impact the treatment of this review by parliamentarians can have, not just with respect to the duration of the Coronavirus Act powers, but also with respect to avoiding what Fiona discusses as constitutional fraying. I'm sure we'll all be looking ahead to the review with eager anticipation to judge the extent to which this is reflected in the proceedings to come. I'd like to thank everyone for attending this seminar. This has been a Join the CIVRO and Bingham Centre for the Rule of Law event. If you'd like to keep up with CIVRO and the Bingham Centre's work, you can follow CIVRO on Twitter at CIVRO UK, that's CVRO UK, and there's a link to our website in our profile. You can also follow the Bingham Centre at Bingham Centre, which also has its website in its profile. The Centre also does a great weekly newsletter that I always look forward to arriving in my inbox on a Friday. So many thanks again to the speakers, and we hope to see you again soon. Bye.